We are set today for a pretrial conference. You're not here. Why are you not here?
Well, there's a few reasons for that, sir. You know, one of the main reasons is I'd like some clarification on the record to be made without getting arrested due to the last appearance. As you know, was physically unable to get there. You're right about my motion. I didn't prove the just cause. I realized that I had to include some exhibits and proof that of what was going on, and I apologize for that. However, um, the last appearance, I was specially appearing to, by special appearance, I was attempting to make it by a special appearance to challenge the jurisdiction of the court due to several issues that have been unaddressed through the entirety of the case. The main ones being the discovery violations, the most recent changing of the discovery files to make all my motions look like I don't know what I'm talking about, and kind of confused a lot of the matters. And it's still the same thing. I mean, just a couple days ago, I got notice that there was another discovery update. I mean, we're well past the motions deadline, and there was a discovery update a week before that, and then another one like a week after, and then now more recent ones. And I just don't really feel like that's really granting me a fair chance at really defending myself when they want to change the names of the files and things like that, as I've like already had submissions that had certain citations to their body cam footages and things like that that have also been unaddressed. It doesn't really provide grounds for fair defense or a reasonable amount of time to be able to defend myself.
All right. Thanks, sir. All right. Here's, I guess, the record I'm going to make. We're set for trial to commence on Tuesday. Mr. Mann, I recognize how you are proceeding this, but I think the record is pretty clear. This case has been going on since 2022. By my count, there are at least 8 failures to appear, and that's at least 8 failures to appear in this case. You've after an Arguello advisement, you've agreed to represent yourself. You were advised and cautioned during the Arguello advisement that you would be required to, when representing yourself, to comply with the rules of criminal procedure, with any rules of evidence during the admission of any evidence. That has not actually even become ripe at this point because we've not had any hearings. This matter's been set for hearings to address your motions on a couple of occasions just since I've been the presiding judge over this case. And I believe in, let's see, let me just want to make sure I'm, yeah, on 11/26, that just myself have granted you extensions to file certain motions, giving you specific deadlines. And on 11/26/2025, I made it very clear what the final deadline was going to be for your motions to be filed, specifically 12/12/2025. Then we were scheduled for a motions hearing on 1/9/2026. That was the day that you appeared via WebEx. I found a failure to appear because you appeared via WebEx and did not give a adequate reason. You had indicated that you may be able to get here by 10:30, and I even stayed the warrant to give you that opportunity. Today, we're set for pretrial conference 1 week away from the beginning of the trial date. You're still not here in person. These motions that you keep on talking about could have been addressed appropriately if you would have followed the court's orders during that time frame. And certainly, if there are issues of discovery that have happened that are not in compliance with Rule 16, the court will hear those. But those, again, you've been complaining about, or challenging, I should say, discovery issues, but you never present yourself on a date that we're...
All right, guys, buckle up, because this courtroom showdown is about to spiral into absolute chaos. Today we're revisiting one of the most unbelievable defendants we've followed in quite some time, Jacob Mann. If you've seen the earlier hearings, you already know this is someone who insisted he understood the law better than trained attorneys and even believed he could outsmart the judge by representing himself. But here's the twist. After repeatedly challenging the court's authority, missing critical hearings, and having a bench warrant issued,
Actually scheduled to address those things, and you have to be here in person. You also have to be here in person for the trial. So again, we're set for a pretrial conference here. I have a jury questionnaire that I'm going to submit to the jury commissioner in preparation for Tuesday's trial. I'm going to bring in 55 jurors for that trial, and the court will be prepared. Well, let me ask the prosecution. Is the prosecution ready to go to trial on Friday? I'm sorry, on Tuesday.
People are ready, Your Honor.
All right. So, Mr. Mann, we're set for trial. I mean, this, again, I'll address any pretrial issues or any discovery issues that have arisen in the last 35 days to determine whether there was any discovery violations. One thing you need to understand is the prosecution has a duty to continue to provide discovery. Oftentimes when they provide discovery just based upon, and I don't know how you're receiving your discovery, but again, these are just things I'll consider, and I'm just saying this for your information. Sometimes when they provide discovery, if they're doing it over what they call evidence.com, which is a system that they use to disclose information, sometimes not the new discovery is provided, but then all the previously provided discovery kind of tags along with it, so it's included with it. I will address any discovery issues that may have arisen in the last 35 days if there's any new discovery that may exist. But those are things that I have to address when you're here in person. You're not here in person. I think I know you're aware that you have a warrant based upon the orders, the motions you filed and the last order I issued in this case. But we are set for trial on Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones and again, Ms. Jones is here only as advisory counsel, unless there's something in particular, Ms. Jones, you think I should be covering, or unless Mr. Duncan wants anything in particular covered. The one thing I will state is just based upon the nature of how things have been
appearing over WebEx instead of showing up in person was a smart legal strategy. That's where today's drama begins. Throughout this hearing, you'll watch the judge patiently explain the same rules over and over while the defendant keeps insisting the court has no authority over him. The tension builds with every exchange, and by the end of this hearing, it becomes painfully clear that confidence without courtroom procedure can be a dangerous combination. Trust me, you won't want to miss what happens next because this case
Monday, he's got a warrant already. So yes, it is a failure to appear. But I still want to pass the information along so we can proceed on Tuesday. I said Monday. On Tuesday's the trial date.
Excuse me. You said quite a bit there. I didn't really get a chance to respond to anything.
There's nothing to respond, sir. I'm just giving you instructions.
I got some things I need to address with the court before we can proceed, sir.
Well, sir, then you need to come to court. We will address those things when you're here in person.
Well,
I'm not going to.
I'm trying to tell you guys need to prove jurisdiction because there was a period of time I sat in prison for almost 9 months and there was no action on the case. That's a failure to prosecute. And I understand the statutory provisions on speedy trial, but there's constitutional provisions. And if the trial ain't had from the date of the start of the case between 180 days and there ain't good cause shown, that means you guys waive jurisdiction.
I will address, sir. I'm asking covered everything I need to cover.
I'm asking you to address it now because before we can proceed, I need you guys to prove that you guys have authority to try the case.
Sir, I've already addressed way more than I needed to. You're not actually here. It is a failure.
No, I am here.
I
mean,
am
you
protecting
waived
your
my
right
rights
to a
you
fair
waived
trial.
my rights to all my motions. I mean, without me even knowing it. I didn't get proper notice of that waiver of rights. You can't just be taking people's rights. I mean, the Constitution forbids that, and the Constitution trumps everything. It doesn't matter what kind of order or ruling of law. If it's against the
All right.
Constitution, you know that you can't be ruling
All
like
right.
that. So,
We are,
can you address that, please?
we are, all right, sir, what I'm addressing is that you're not here. And the one thing I will say is you were on notice as to what the motions date was, and you failed to appear on the motions date. You
Well,
have
no,
to be in
actually, I
person.
attempted to appear
in
by
court.
video because I couldn't get there, and I wish
I-
the record would reflect that.
You,
Because I did try
sir,
to-
the record is made on this case. Okay, this matter is now in recess.
Okay.
You have a trial on Tuesday. You need
That's
to be
cool.
here in person.
Hearing takes a very important turn. Notice that the judge isn't arguing about constitutional theories or trying to win a debate. Instead, he keeps bringing the conversation back to one simple issue: court procedure. Whether someone agrees with the charges or not, courts operate under established rules, deadlines, and appearance requirements. The judge even
Of appearance,
Todd Duncan for the people.
and Miss Jones, Jessica Jones, is here as advisory counsel for Mr. Mann. Mr. Mann is not in the courtroom. I guess I'll just ask, do either party have any information relating to Mr. Mann as to why he's not here today?
No record,
Okay.
Your Honor, that I
All
can
right.
make on his behalf. I don't represent him.
No, I understand. Just didn't know if there's any communication or anything, but all right, we're set for trial. I'm going to make well, let me find out. Is there any record that, and Ms. Jones, I 100% recognize that you don't represent him, but is there any record you need to make of any kind?
Your Honor, I have been in touch with Mr. Mann as he has been attempting to prepare for his trial this morning throughout the long weekend. I know that he is scared, he is confused, he has many questions about how to proceed as a pro se individual. I did my best to try to assist him in that manner, but I don't represent him.
No, it's fine. It's fine. I just, all right, I need to make a record. So, because frankly, based upon the nature of this case as a whole, I think the court needs to take some appropriate action on the bond issues on this case. So I guess I'll go back to the last court date, which was on 2/10 of 2026. Mr. Mann, that was set for a pretrial conference. And Mr. Mann, at that point, kept on arguing, or was trying to argue, that the court lacked jurisdiction, and based upon what he was saying, he indicated because the case has not been brought to trial within a certain period of time. He was presumably making some kind of a speedy trial argument. So the court believes that it's relevant to make this record, both to establish why, at least based upon the court's review of the record, there's not ever been an issue of speedy trial in this case, and two, why at this point I believe a new bond. I mean, he's already on a bench. There's already a bench warrant that has been issued in the case against him, but the court finds that a bond modification is now required for his failure to appear at trial. It was made very clear to him on 2/10/2026, even though the court found that he failed to appear because he was on WebEx, the court at least gave him the courtesy of explaining to him how jury selection would go, the fact that there's a trial and that he was expected to be here for the trial. This case has been set for trial now 4 times. This is the 4th trial setting. The first trial setting was continued. Well, he pled not guilty back in 10/10 of 2024, so October 10 of 2024. And most of this is based upon the court's review of the record. That's when he pled not guilty. The trial was set for 9/25/2024. I'm sorry, I just confused the record here. I'm sorry. On 4/10/2024, he pled not guilty. Speedy trial was then 10/10/2024. And the trial was then set on 9/25/2024, so before the speedy trial date. There was a 35 days, an order from the court for the defendant to file motions 35 days prior to the motion setting date, which was set on 8/2/2024. That matter was continued at the defendant's request, and a second trial setting was then set. So the new speedy trial date on the second trial setting, which was set on 7/30/2024,
Explains that discovery disputes can absolutely be addressed, but only if the defendant follows the proper process and actually appears when those hearings are scheduled. That's the key difference here. One side is focused on legal procedure, while the other continues circling back to jurisdiction arguments before resolving the procedural problems already standing in the way. What do you think? Is the defendant making legitimate procedural complaints, or is he undermining his own case by refusing to follow the court?
For appearance on arrest warrant, I'll take entries starting with the people.
Will applicant for the people.
Thank you.
And Jessica Jones, as advisory counsel for Mr. Mann, he is pro se.
Okay, thank you, folks. This matter comes on for appearance on an arrest warrant as noted, following failure to appear for jury trial scheduled on February 18th. I'll note that the court found a waiver of speedy trial on that date. Speedy trial will begin to run again today. So for the record, speedy trial will be August 26th, absent any tolling or waivers. Mr. Atherton, how are you asking to proceed, sir?
Your Honor, in speaking with Ms. Jones, and I understand Mr. Mann is pro se and she's serving as advisory counsel. I was going to ask the court if we could set this matter over until tomorrow. I know this court is covering for Division E tomorrow as well. I don't know what this court's docket is like, but the reason for that is Mr. Duncan is assigned to these cases. He has very intimate knowledge of the cases. He's been working on them for a long period of time. He's out today. It was, a surprise that Mr. Mann was on the docket. I know he was recently arrested, so not too much of a surprise, but I do want to give Mr. Duncan the opportunity to handle anything on the case and be present for this if the court could accommodate and if that's what Mr. Mann would like to see as well.
Okay. Mr. Mann, what would you like to do, sir?
Well, there was a deal put on the table, and everybody's aware of the deal in the case. So, if we could just simplify this matter, and I could just bite on that deal today. It was a plea guilty to DM1 and a 22 CR 2848, and then a DF4 in the other case. And I'm prepared to take that deal right now. If we can just simplify everybody's time, and we can just go ahead and do immediate sentencing too.
Okay. And so I can't get involved in plea negotiations, but Mr. Atherton, your position on that request?
Sorry.
And that's what I was kind of referring to. I don't want to get into too many details for that reason, Your Honor. Mr. Duncan previously made FRI records in the case, so that's what I want to give him the opportunity to figure out and be present for.
Okay. So given that Mr. Duncan is not available this morning and the nature of the add-on this morning, I do find good cause to continue this to tomorrow. So we're not going to have significant delays, but it sounds like Mr. Atherton can't move forward on any prior plea offers. I'll leave that to the people of Mr. Mann and Ms. Jones to discuss, but we'll continue this to tomorrow for setting. Speedy trial will still be running, so you won't be losing any time on that speedy trial date. Go ahead, Mr. Mann. Did you have something else, sir?
Yeah. One other thing is I'd like to address the bond, because there was an issue where, my I don't know, to my understanding that this whole trial is going to be reset then, is that correct?
Yes, if there's not a resolution.
Basically, they're going to start over from motions and all that. Is that what's going on, or what's the procedure on this?
Well, I can't say for sure because, I'm not Judge Hernandez. I didn't preside over all of the hearings. If there are motions that need to be relitigated, we can set a new motion.
So the issue I'd like to address is the bond. Basically, there was a deal where I had an outstanding warrant in another jurisdiction the day of motions hearing, and I tried to go get that handled before I came to the motions hearing. Well, there was a snowstorm that night, and I wasn't allowed to travel the next morning, made it so I was not able to handle either one of them. The judge basically issued that I had an hour to get to the courthouse the day of the snowstorm, and I tried to do that. I didn't make that either. So then they decided that I waived my right to motions hearing. Well, I put in a motion to quash that warrant, and I would like to basically say that, I'd like to readdress that with this court, because I showed good cause on why I couldn't make that 1 hour deadline. And I believe that basically, I didn't run on this case. I didn't try to hide. I didn't do nothing. They found me right at my house. I didn't try to resist. I didn't do nothing. I told them they knew right where I was going to be, because I even hardly leave my house, because all I do was work on this case all day and night. So basically, I'd like to ask that bond be reinstated and the warrant quashed from that moment, so I could proceed from what happened before that. Basically, I think would be like a abuse of judicial discretion on part of the judge on not letting me quash that warrant, because that's the only reason why I missed the trial, is because they wouldn't let me just reinstate my bonds. They wanted to basically have me pay more money, which is basically a form of extortion, when they know that, like, basically it was just going to restore me back to where I would have been at before all this happened.
Okay.
So I'd like to ask for basically to restore the original bond of the, what was it, 30,000 cash surety, and basically have all the judgments since then vacated, voided.
Okay. All right, thank you, Mr. Mann. So I'm going to take what you said into account. I'm not going to address bond today.
And that's where this chapter of Jacob Mann's courtroom saga comes to a close. Despite multiple warnings, repeated opportunities to appear, and the court's willingness to hear his procedural arguments in person, the central issue never changed. He simply failed to comply with the court's appearance requirements. The judge made it clear that every defendant has the right to defend themselves, but those rights come with responsibilities and procedural rules that apply equally to everyone. As this case moves toward trial,